Good afternoon, everyone. I call this meeting to order. Welcome to meeting number 92 of the House of Commons Standing Committee on Industry and Technology. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Pursuant to the order of reference of Monday, April 24, 2023, the committee is resuming consideration of Bill C-27, an act to enact the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act, and to make consequential and related amendments to other acts. I'd like to welcome our witnesses today, and I apologize for this brief delay, which was caused by a vote in the House. Today we have with us Colin J. Bennett, Professor. We have Michael Geist, Professor of Law, Canada Research Chair in Internet and E-Commerce Law. We have Vivek Krishnamurthy, Associate Professor of Law, University of Colorado Law School by video conference. We have Dr. Brenda McPhail, Acting Executive Director, Public Policy and Digital Society Program. And finally, Teresa Scassa, Canada Research Chair in Information Law and Policy, Faculty of Law, Common Law Section, University of Ottawa. I would like to welcome each and every one of you, and I will begin without further delay with Mr. Bennett for 5 minutes.
Thank you very much, Mr. Chair. And I'm from the University of Victoria, although I'm currently in Australia, so I wish everybody a good day. I would like to emphasize 5 specific areas of reform of the CPPA and suggest ways in which the bill might be brought into better alignment with Quebec's Law 25. I don't think C-27 should be allowed to undermine Quebec law, and in some respects it does. I also think these are some of the areas where the bill is vulnerable when the European Commission comes to evaluate whether Canadian law continues to provide an adequate level of protection. Some of these recommendations are taken from the report that you have for the Centre for Digital Rights, which I'd like to commend to you. First, I believe that Section 15 on consent is confusing to both consumers and to businesses. In particular, I question the continued reliance on implied consent in Section 15.5, which states that consent must be expressly obtained unless it is appropriate to rely on individuals' implied consent. And the bill enumerates those business activities to which consent is not required, including if the organization has a legitimate interest that outweighs any potential adverse effect on the individual. That's a standard that's been imported from the GDPR. But in the GDPR, consent means express consent, freely given, specific, informed, and unambiguous. Now, in the current version of CPPA, businesses can have it both ways. They can declare that they have implied consent because of some inaction that a consumer allegedly took in the past because of not reading the legalese and the complex terms of service agreement, or they can assert a legitimate interest in the personal data by claiming that there is no potential adverse effect on the individual. And that is a risk assessment performed by the company rather than a judgment made about the human rights of individuals to control their personal information. In that respect, it's really important that the bill be brought within a human rights framework. So there should be no room for implied consent in this legislation. It's a dated idea that creates confusion for both consumers and for businesses. Second, there's no section in the CPPA on international data transfers. I find that very odd. I know of no other modern privacy law that fails to give businesses proper guidance on what they have to do if they want to process personal data offshore. The only requirement is for the organization to require the service provider, by contract or otherwise, to ensure a level of protection of the personal information, quotes, equivalent to that which the organization is required to provide under this act. That's section 11.1. Now, that due diligence applies whether the business is transferring personal data to another province in Canada or overseas to a country that may or may not have strong privacy protection, or indeed a record of the protection of human rights. And that's particularly troubling because of Section 19, which says that an organization may transfer an individual's personal information to a service provider without their knowledge or consent. Now, the Canadian government has never got into the business of adopting a safe harbor approach or whitelists, and I'm not recommending that. But Quebec, I believe, has legislated an appropriate compromise under Section 17 of Law 25, which requires businesses to do an assessment, including of the legal framework, when sending personal data over outside of Quebec. And as many businesses will have to comply with the Quebec legislation, why not mirror that provision in C27? Thirdly, the bill ignores important accountability mechanisms that were pioneered in Canada and exported to other jurisdictions, including Europe. It's therefore very strange that those same measures do not appear in the CPPA. In particular, privacy impact assessments are an established instrument and a critical component of accountable personal data governance, and they should be required in advance of product or service development, particularly where invasive technologies and business models are being applied, where minors are involved, where sensitive personal information is being collected, or where the processing is likely to result in a high risk to an individual's rights and freedoms. Businesses do the PIAs and they stand ready to demonstrate their compliance or their accountability to the regulator. A fourth and related problem is the absence of any definition of sensitive forms of personal data. Now, the word sensitivity appears throughout the legislation in several provisions of the bill, but with the exception of the specification about data on minors, it is nowhere defined. And in my view, the bill should define what sensitive information means, and it should also enumerate a non-exhaustive list of categories, which in fact occurs in many forms of legislation. And finally, and I know you've heard about this in the past, I've researched on this, the absence of proper privacy standards for federal political parties is unjustifiable, it's untenable. The government's relying on the argument that FPP's privacy practices are regulated in the Elections Act, but those provisions are nowhere near as strong as in C27. I think businesses resent the fact that parties are exempted. So that is not an issue that's going to go away, given advances in technologies and its uses in modern digital campaigning. Canada is one of the only countries in the world in which political parties are not covered by applicable privacy law. Thank you so much. Merci beaucoup.
Thank you very much, Mr. Bennett. I'll now give the floor to Mr. Professor Geist here with us in Ottawa.
Great. Thank you very much, Chair. Good afternoon. As you heard, my name is Michael Geist, law professor at the University of Ottawa, where I hold the Canada Research Chair in Internet and E-commerce Law, and I'm a member of the Centre for Law, Technology and Society, appear in a personal capacity representing only my own views. I'd like to start by noting that the very first time I appeared before a House of Commons committee was in March 1999 on Bill C-54, which would later become PIPEDA. I must admit, I don't think I really knew what I was doing at that appearance, but my focus at the time was on whether or not the law would provide sufficient privacy protections for those just coming online, who had little background or knowledge of privacy, security, or even the internet for that matter. I highlighted some of the shortcomings of the bill, including poorly defined consent standards that would lead to over-reliance on implied consent, broad exceptions on use or disclosure of personal information, and doubts about enforcement. Urged the committee to strengthen the bill, but I have to say that I didn't fully appreciate that the policy choices being made back then would last for decades. I start with this brief trip down memory lane because I feel we find ourselves in the same position or a similar position today, with policy choices on things like artificial intelligence and emerging technologies that will similarly last for far longer than we might care to admit. It's for that reason that I think it's important to emphasize the need to get it right rather than get it fast. I often hear the minister talk about being first, at least on AI, and I must admit I don't understand why that is a key objective. Indeed, if you leave aside the fact that the core of at least the privacy part of this bill was introduced in 2020 and languished for years, we now find ourselves in a race to conduct hearings that I don't totally get. We've got an AI bill where there's a major overhaul with no actual text available yet, and witnesses seemingly have to pick between privacy and AI, creating the risk of limited analysis all around. I think we need to do better. I'll focus these remarks on privacy, but to be clear, the AI bill and the proposed changes raise a host of concerns, including the need for independent enforcement and the high impact definitions that puzzlingly include search and social media algorithms. The other lesson from the past 2 decades is that you can seek to create a balanced statute, and I know there's been a lot of talk about balance, but the playing field will never be balanced. It's always tilted in favor of business, many of whom have the resources and expertise to challenge the law, challenge complaints, challenge the Privacy Commissioner. Most Canadians don't stand a chance. That's why we must craft rules that seek to balance the playing field too, with broad scope of coverage, better oversight and audit mechanisms, and tough penalties to ensure that the incentives align with better privacy protection. How do you do that? Given my limited time, 5 quick ideas. First, and this is going to pick up where Professor Bennett ended, we must end the practice of do what I say, not what I do when it comes to privacy. I think it's unacceptable in 2023 for political parties to exempt themselves from the standards they expect all businesses to follow. Indeed, you can't credibly argue that privacy is a fundamental right and then claim that it should not apply in a robust manner to political parties. Second, the addition of language around fundamental right to privacy is welcome, but I think it should also be embedded elsewhere so that it factors more directly into the application of the law. For example, as former Commissioner Tarian noted, it could be included in Section 12, Sub 2, among the factors to consider in an appropriate purposes test. Third, the past 20 years has definitively demonstrated that the penalties matter for compliance purposes and are a critical part of the balance. The bill features some odd exclusions. There's penalties for elements of the appropriate purposes provision in Section 12, but not the main provision limiting collection, use, and disclosure for appropriate purposes. In the crucial Section 15 provision on consent, there are no penalties around the timing of consent or for using an implied consent within the legitimate interest exception. The bill says such practice is not appropriate, whatever that means. It's an odd turn of phrasing in a piece of legislation, but the penalty provision doesn't apply regardless. Fourth, the committee has already heard debate about the appropriate standard of anonymized data, and I get the pressure to align with other statutes. But I'd note that Section 6 sub 6 specifically excludes anonymized data from the Act, yet I think we want to ensure that the Commissioner can play a data governance role here, with potential audits or review, particularly if a lower standard is adopted. Finally, fifth, provided we ensure that the Privacy Tribunal is regarded as an expert tribunal that will be granted deference by the courts, I'm okay with creating another layer of privacy governance. I appreciate the concerns that this may lengthen the timeline for resolution of cases, but the metric that counts isn't how fast the Privacy Commissioner can address an issue, but how fast a complainant can get a binding final outcome. And given the risks of appeals and courts treating cases on a de novo basis, existing timelines can go far beyond the Commissioner decision, and a tribunal might actually help. Thanks for your attention. I look forward to your questions.
Thank you very much, Mr. Geist. We'll now turn to Professor Vivek Krishnamurthy. The floor is yours.
Thank you, Mr. Chair and members of the committee. I'm very honored to be speaking with you today regarding Bill C-27. I'm currently a professor of law at the University of Colorado, but when I was the director of CIPIC at the University of Ottawa, we published 2 reports in the spring of 2023 that consider ADA and the CPPA. I'm going to focus my remarks on the CPPA, particularly provisions that relate to the privacy of minors. I would be happy to share some of my thoughts about ADA as well. And I'd like to begin by saying that I agree with everything that Professors Bennett and Geist said. So you could treat these remarks as additive. While it is very welcome that the CPPA, unlike PIPEDA, specifically defines that the personal information of minors is sensitive information, Professor Bennett already told you about how sensitive information is not a defined term in the legislation. So it's positive that children now have, if this bill passes into law, some recognition of the importance of protecting their personal information to a higher standard. However, we believe that this legislation can do far better. For context, it is important to realize that children spend increasing amounts of time online at younger and younger ages. And this was a trend that accelerated with COVID-19 and the transition to digital online learning. I'm a parent. I'm sure that many of you are parents, and our children are using devices under commercial terms of service all the time. And this poses a very significant risk to the privacy rights of children. While COVID has receded, this is with us. It's new reality that kids are using more and more technology at younger ages. So what can we do? 3 things, and then a 4th about jurisdictional competence. The Privacy Commissioner, in his recommendations regarding the CPPA, suggests that best interests of the children language should be incorporated into the law, and he suggests doing that in the preamble. I take no position myself on where that should be done, but it is clear that this is international best practice. The United Kingdom and California have both incorporated such language into recently enacted statutes, and we think that Canada should follow this approach. What would that mean? It means that organizations that handle children's personal data must take the best interests of children into account, and that must come ahead of their commercial interests. Second, we think it is important for the CPPA to require organizations that develop products or services that are likely to be accessed by children to set their privacy settings to the highest level. So defaults play a really important role in our subjective experience of privacy. It's great to have rights, but you can very easily leave those rights on the table if a setting is set in a way that, well, it contracts you out. So we think that requiring the highest level, that companies set those defaults to high levels when they're children are their likely users or their known users, is very important. Third, picking up on what Professor Bennett told you about data protection impact assessments, a made in Canada idea. C27 is extremely weak when it comes to data protection impact assessments. The provisions only apply when the legitimate interest exception to consent is being used. This is a problem for everyone, but especially for children. We believe, and so CIPIC believes, and I believe this personally, that the data protection impact assessment bill requirements of this bill need to be considerably strengthened to whenever data processing activities pose a high risk to the privacy rights of Canadians. And I would say that if children's data is sensitive data, that means basically all the time you need to do that impact assessment. Lastly, I'd like to talk a bit about constitutional competence here. There may be some concerns that it may be beyond federal competence to protect the privacy rights of children with more expansive provisions. Our analysis suggests otherwise. CPPA, like PIPEDA before it, is being enacted under Parliament's power to regulate trade and commerce. Now, it's true that in our federal system, provincial governments get to determine the age of majority, but there is plenty of federal legislation that is designed to protect the rights of children. And this also leads to, how do we think of this law, the Consumer Privacy Protection Act? It's not just only a form of privacy regulation, but it's also a form of, when you think about it, consumer protection legislation that is regulating the safety of digital products that invade and interfere with our right to privacy. So in view of the long history of federal regulation directed at protecting children in the marketplace, we think it would be appropriate for the federal government to include stronger privacy protections, and that would not prejudice provincial laws like Quebec's that are stronger. Just as PIPEDA yields to provincial legislation when it's substantially equivalent or better, the same could be true of strengthened children's privacy protections in the new CPPA. Thank you very much.
Merci beaucoup. Je passerai maintenant la parole à Mme.
Thank you very much, and I'll give the floor to Ms. Brenda McPhail.
Thank you, Mr. Chair and members of the committee, for inviting me here today to speak to the submission authored by Jane Bailey, professor at the University of Ottawa, Faculty of Law, Jacqueline Burkell, Faculty of Information and Media Studies at Western University, and myself, currently the acting executive director of the Public Policy and Digital Society program at McMaster University. It is a privilege to appear before you on this omnibus bill that needs significant improvement to protect people in the face of emerging data-hungry technologies. I will focus on part 1 and very briefly on part 3 of the bill in these initial remarks, and welcome questions on both. Privacy, of course, is a fundamental underpinning of our democratic society, but it is also a gateway right that enables or reinforces other rights, including equality rights. Our written submission explicitly focuses on the connection between privacy and equality because strong, effective privacy laws help prevent excessive and discriminatory uses of data. We identify 8 areas where the CPPA falls short. In these remarks, I will focus on 4. First of all, privacy must be recognized as a fundamental human right. Like others on this panel, while we welcome the suggested amendments suggested by Minister Champagne, we would note that Section 12 in particular also requires amendment so that the analysis to determine whether information is collected or used for an appropriate purpose is grounded in that right. Bill C-27 offers a significant improvement over PIPEDA in explicitly bringing de-identified information into the scope of the law, but has diminished the definition from the predecessor law, C-11, Bill C-11, by removing the mention of indirect identifiers. The bill also introduces a new category, anonymized information, which is deemed out of scope of the Act in contrast to the superior approach taken by Quebec. Given that even effective anonymization of personal data fails to address the concerns about social sorting that sit at the junction of privacy and equality, all data derived from personal information, whether identifiable, de-identified, or anonymized, should be subject to proportionate oversight by the OPC, simply to ensure that it's done right. Third, Section 12 sub 4 weakens requirements for purpose specification. It allows organizations to use information collected for one purpose for something else simply by recording that new person any purpose any time after the initial collection. How often have you shared information with a business and then gone back a year later to see if they had changed their minds about how they're going to use it? At a minimum, the bill needs constraints that limit new uses to purposes consistent with the original consensual purpose. Finally, the CPPA adds a series of exceptions to consent. I'll focus here on the worst, the legitimate interest exception at Section 18.3, which I differ from my colleagues in believing should be struck from the bill. It is a dangerously permissive exception that allows collection without knowledge or consent if the organization who wants the information decides their mere interest outweighs adverse impacts on an individual. This essentially allows for collections for organizational purposes that don't have to provide benefits to the customer. Keeping in mind that the CPPA is the bill that turns on or off the tap for the ADA, this exception opens the tap and then takes away the handle. Here I'd commend to you the concerns of the Right to Your Face Coalition, which flags this exception as one way in which organizations may attempt to justify and hide their use of invasive facial recognition technology. Turning to Part 3 of Bill C-27, the ADA received virtually no public consultation prior to being included in C-27, and that lack of feedback has resulted in an act that is fundamentally underdeveloped and prioritizes commercial over public interests. The act, by focusing only on high-impact systems, leaves systems that fail to meet the threshold unregulated. AI can impact equality in nuanced ways not limited to systems that may be obviously high impact. And we need an act that is flexible enough to also address bias in those systems in a proportionate manner. A recommender system is mundane these days, yet can affect whether we view the world with tolerance or prejudice from our filter bubble. Election time comes to mind as one where that cumulative impact could change our society. Maybe that should be in and maybe it should be out. We just haven't had the public conversation to work through the range of risks, and it's a disservice to Canadians that we're reduced to talking about amendments to a bad bill in the absence of a shared understanding of the full scope of what it needs to do and what it should not do. Practically in our submission, we nonetheless make specific recommendations in our brief to include law enforcement agencies in scope, create independent oversight, and amend the definitions of harm and bias. And we further support those recommendations submitted by the Women's Legal Education and Action Fund. I'd be very happy to address all of these recommendations during the question period, and thank you.
Merci beaucoup. Et,
Thank you very much. And to conclude, I'll now give the floor to Teresa Scassa for 5 minutes.
Thank you very much, Mr. Chair, for the invitation to address this committee. I'm a law professor at the University of Ottawa, where I hold the Canada Research Chair in Information Law and Policy. I'm appearing today in my personal capacity. I have concerns with both the CPPA and the ADA.
Monsieur le Président, je veux vous arrêter. L'interprétation ne se fait pas.
okay, just 1 minute, Mme Scassa. We'll just make sure
Oui,
that interpretation
ça fonctionne.
Oh, now it's working. Thank you.
Resume.
Okay, thank you. So I have concerns with both the CPPA and ADA. Many of these have been communicated in my own writings and in the reports submitted to this committee by the Center for Digital Rights. My comments today focus on the Consumer Privacy Protection Act. I note, however, that I have very substantial concerns with the AI and Data Act and would be happy to answer questions on it as well. Let me begin by stating that I'm generally supportive of the recommendations of Commissioner Dufresne for the amendment of Bill C-27 set out in his letter of April 26, 2023 to the chair of this committee. I will also address 3 other points. The minister has chosen to retain consent as the backbone of the CPPA with specific exceptions to consent. One of the most significant of these is the legitimate interest exception in section 18.3. This allows organizations to collect or use personal information without knowledge or consent if it's for an activity in which an organization has a legitimate interest. There are guardrails. The interest must outweigh any adverse effects on the individual. It must be one which a reasonable person would expect, and the information must not be collected or used to influence the behavior or decisions of the individual. There are also additional documentation and mitigation requirements. The problem lies in the continuing presence of implied consent in Section 15 sub 5 of the CPPA. PIPEDA allowed for implied consent because there were circumstances in which it made sense and there was no legitimate interest exception. However, in the CPPA, the legitimate interest exception does the work of implied consent. Leaving implied consent in the legislation provides a way to get around the guardrails in Section 18 sub 3. An organization can opt for the implied consent route instead of legitimate interest. It will create confusion for organizations that might struggle to understand which is the appropriate approach. The solution is simple: get rid of implied consent. I note that implied consent is not a basis for processing under the GDPR. Consent must be express, or processing must fall under another permitted ground. My second point relates to Section 39 of the CPPA, which is an exception to an individual's knowledge and consent where information is disclosed to a potentially very broad range of entities for socially beneficial purposes. Such information need only be de-identified, not anonymized, making it more vulnerable to re-identification. I question whether there is social license for sharing de-identified rather than anonymized data for these purposes. I note that Section 39 was carried over verbatim from Bill C-11 when de-identify was defined to mean what we now understand as anonymize. Permitting disclosure for socially beneficial purposes is a useful idea, but Section 39, especially with the shift in meaning of de-identify, lacks necessary safeguards. First, there's no obvious transparency requirement. If we're to learn anything from the ETHI Committee inquiry into PHAC's use of Canadians' mobility data, transparency is fundamentally important. At the very least, there should be a requirement that written notice of data sharing for socially beneficial purposes be given to the Privacy Commissioner of Canada. Ideally, there should also be a requirement for public notice. Further, Section 39 should provide that any sharing be subject to a data sharing agreement, which should also be provided to the Privacy Commissioner. None of this is too much to ask where Canadians' data are conscripted for public purposes. Failure to ensure transparency and some basic measure of oversight will undermine trust and legitimacy. My third point relates to the exception to knowledge and consent for publicly available personal information. Bill C-27 reproduces PIPEDA's provision on publicly available personal information, providing in Section 51 that, and I quote, an organization may collect, use, or disclose an individual's personal information without their knowledge or consent if the personal information is publicly available and is specified by the regulations. We have seen the consequences of data scraping from social media platforms in the case of Clearview AI, which used scraped photographs to build a massive facial recognition database. The Privacy Commissioner takes the position that personal information on social media platforms does not fall within the publicly available personal information exception. Yet not only could this approach be upended in the future by the new Personal Information and Data Protection Tribunal, it could also easily be modified by new regulations. Recognizing the importance of Section 51, former Commissioner Terrien had recommended amending it to add that publicly available personal information be such that the individual would have no reasonable expectation of privacy. An alternative is to incorporate the text of the current regulations specifying publicly available information into the CPPA, revising them to clarify scope and application in our current data environment. I'd be happy to provide some sample language. This issue should not be left to regulations. The amount of publicly available personal information online is staggering, and it is easily susceptible to scraping and misuse. It should be clear and explicit in the law that personal data cannot be harvested from the internet except in limited circumstances set out in the statute. Finally, I add my voice to those of so many others in saying that data protection obligations set out in the CPPA should apply to political parties. It is unacceptable that they do not. Thank you.
Thank you, Professor Scassa. Just before I open the discussion to Mr. Williams, I think I speak on behalf of the committee to ask you if you could provide that language to improve Section 51 to the committee. That would be much appreciated. Yes, I know then Mr. Perkins won't have to ask it. Yes, so Mr. Williams, the floor is yours.
Thank you, Mr. Chair. And after 8 long years, we've finally had privacy legislation in front of this committee. Of course, we've heard from witnesses, it's been actually 24 years since we updated the last privacy legislation. And when we looked at this in the first reading in the House or second reading, we really focused on what was missing in this bill. What was missing was listing privacy as a fundamental right. But then when we came to committee and we had witnesses lined up, the minister then added a bunch of amendments, and the amendments seemed to indicate that he was listening. But of course, we're not sure where we are because amendments will go in certain parts of the bill. Mr. Geist, thank you for appearing today. When we had the original copy of this, I understand you were part of the original iteration of this bill, PIPEDA, 24 years ago. You don't look that old, sir. But the minister came, he had presented a bill, did not list privacy is a fundamental right, and then have these amendments. Did the minister break this bill?
Well, I felt when the minister first came to committee and suggested a whole raft of changes and then indicated that the government was not prepared to provide the actual text of those amendments until clause by clause. To me, that broke the hearings. For myself, for my fellow witnesses, for the many witnesses to come, we follow closely the idea that you can come before committee and comment intelligently when you don't have the actual text of the legislation. Means to me that everybody's time is being wasted a little bit because you're basically commenting on an old bill rather than where things are headed. I'm glad that there are now some amendments there, but obviously we're carrying on. We don't have the specific language around the AIDA, and even on the, as I mentioned in my opening remarks, even around the issue of fundamental right to privacy, I think we can still do better.
And just for the record, sir, do you believe that privacy should be listed as a fundamental right in the first two sections of this bill?
I do. I do. I mean, I think that would provide clarity in terms of how it is interpreted, obviously, by the commissioner as well as by the courts, and provides a strong signal from the legislative branch of the importance that it accrues to privacy. But as I mentioned, in many respects, I think I'd love to see this in some core provisions that are ultimately going to serve as sort of the testing ground when there's analysis. When you make the determination, for example, is consent appropriate? Well, or is it more even for? Is it the appropriate purpose? Well, that's where you can begin to bring in that privacy is a fundamental right, because at that stage, you're engaged a little bit in some of that balancing, rather than sort of that more overarching side, which it seems to me may come at a later date. A court's reviewing a decision. Did the commissioner take adequate account of the fact that privacy has that elevated status?
Speaking of how important this is for all sections, you were involved 24 years ago in the first generation. Sorry, I'm going to keep repeating that. But how hard is it, once we enact this legislation, to reverse that legislation or update it?
Yeah, I must admit, I'm genuinely surprised at how hard it becomes. I think part of it is because, as you will see throughout the course of these hearings, you end up with people coming from all different perspectives. This isn't a big political winner, I don't get the sense. I think it's critically important legislation, but it's not the thing that is seen as necessarily driving votes, and so it tends to slip. We've seen it with this legislation itself. So even with PIPEDA, with a mandatory 5-year review, we got that first review after 5 years. It took years before those recommendations were acted on, and we have effectively never really seen an effective subsequent review since. So I think it's fairly clear that whatever choices get made now, we live with, you need to be prepared to say, we're comfortable that these will be the rules in 2035 or maybe even 2040. And that means, I think, doing your best to get it right, not doing your best to get it fast.
So on that note, we have a third section here. Seems to be hastily put together. Seems that we didn't have public consultation. Is it Canada's best interest to be first out of the gate on AI legislation?
It's Canada's interest to get what is a critically important issue, appropriate regulation of artificial intelligence, right. And the idea that we want to race ahead with no consultation, we saw the government do the same on the generative AI guardrails that were conducted privately in secret over the summer and then rushed out with practically no public discussion. This is just the wrong way to do something that I think all Canadians have an active interest in. And when we see some of the developments taking place around the world, it becomes essential that both in terms of the kinds of protections Canadians might get with AI systems, as well as some of the economic interests driven by adoption of AI, we want to ensure that I think we contribute to that global conversation, and we ensure that some of our rules are broadly consistent with where things are headed, provided that they meet the kind of standards that we're looking for. And in this instance, it's hard to figure out what the government is doing other than it raced out a sort of a skeleton piece of legislation, got criticized for the lack of consultation and the lack of detail, now says, okay, we'll provide more detail that makes it look a little bit more like Europe, but we don't even have the language on that yet either.
I'm going to ask you a broad question, fundamental though. Who owns Canadians' data?
Well, I think we as individuals, of course, ought to be the ones that own and certainly control our own data. That doesn't mean that we can't make decisions about how organizations use that information. But what it requires is legislation that ensures that we have that effective control, that it's informed, as you heard several witnesses talk about the problems with things like implied consent, and that there are real penalties when organizations run afoul of what they've committed to Canadians or run afoul to the law itself.
Thank you, Mr. Guest.
Thank you very much. Je passerai maintenant la parole.
I'll now give the floor to Mr. Gahir for 6 minutes.
Great. Thank you, Chair, and thank you to all the witnesses for making time for the committee and for their testimony. My questions are for Ms. McPhail. So in the brief that you co-authored and submitted to the committee, you recommended that Bill C-27 be amended to ensure continued and appropriate protection of de-identified and anonymized information. Now, we spent our last committee meeting, I think on Monday, there was witnesses that talked about maybe the definition is too stringent, that we've raised the bar too high. So I wanted to ask, what are your concerns regarding the protection of de-identified information and anonymized information in the CPPA, and perhaps how it can be amended to address your concerns?
Thank you for that question. I think there will always be differences of opinions as to whether definitions are sufficiently stringent or overly weak. What would address our concern? There are three sort of categories of concerns that we have around de-identified and anonymized information. The first is that the definition has been weakened between Bill C-11 and the current iteration in C-27. In the past definition, it included indirect identifiers. So you can identify me by my name, but you can also identify me if you have a combination of my postal code and my gender and a few other factors about me. To de-identify information to an adequate standard where re-identification is unlikely, I believe, and my co-submitters believe, that definition should include indirect identifiers. To some degree, that definition has been weakened because Bill C-27 includes the addition of a new category of information, anonymized information. The problem with that new category is that I think technically people agree that it's extremely difficult to achieve perfect and effective anonymized information. And by taking anonymized information out of the scope of the bill, what we do is remove it from the ability of the Office of the Privacy Commissioner of Canada to inspect the processing that has happened to ensure that it has been done to a reasonable standard. I think, like some of the witnesses that you heard from who would disagree with me about whether or not definitions should be stronger or weaker, I think we all agree on the reality that when personal information is processed, whether it is used to create de-identified information or anonymized information, there should be some checks and balances to make sure that the companies doing it are doing it to a reasonable standard that is broadly accepted. And the way to achieve that is by including the ability within the bill for the Privacy Commissioner's Office to inspect that processing and give it a passing grade should that be necessary. The last piece of concern we have with anonymization that makes that scrutiny even more important is that the bill conflates anonymization with deletion. We heard it was introduced to great fanfare when this bill was put forward, that individuals would now have a right to request deletion of their personal information from the companies with whom they deal. That right, I believe, is rendered moderately illusory. Certainly, members of the public would not expect that if they ask for their information to be deleted, an organization could say, yes, we'll do that, and then simply anonymize the information and continue to use it for their own purposes. If we are going to allow anonymized information to be equivalent to deletion, again, it's incredibly important that we are 100% certain that that equivalency is real and valid, that truly no individual can be identified from that information and that it's not going to harm them in its use after they've explicitly exercised the right to ask for deletion.
No. So are you saying that there are sort of levels to how anonymized data can be? Because, if it's de-identified or it's anonymized, that would imply that you can't identify the person from it. So you're saying that even after sort of meeting the bar of what this legislation puts forward, that there are companies or there are individuals that can piece data together to find out the individual, the identity of that individual?
Roughly speaking, de-identified information should make it highly unlikely that an individual could be identified. Anonymization should make it impossible. But there are really important technical conversations happening about whether it's truly possible in our big data age, where we've got data brokers that advertise that they have data points, thousands of data points on up to 2 million or 2 billion people, that it's possible that some recombination of data wouldn't facilitate re-identification. It's unlikely. It's not a risk that should be at the top of our consideration, but it should be there. And if this bill is to provide appropriate protection for people, assuring that the technical standards of anonymization, which are, computer science is a changeable field. These standards change over time. Assuring that someone has the oversight to ensure that the standards being used are appropriate in the circumstances is fundamentally important.
Great, thank you. I wanted to quickly speak about, Chair, so how much time do I have left?
Sure. You're out of time, Mr. Gayer, but I'm willing to let you go if you have one short question. Zero questions are good, so.
Keep going. So this is not a short question. It was going to be about the exceptions to consent. I know the witnesses talked a lot about the legitimate interest exception. I just wanted to quickly, if I can shorten the question down. I don't think without that exception we would have things like Google Street View. So I wanted to get Ms. McPhail's view on the legitimate interest exception, because I think without that you can stifle innovation in unforeseen ways.
I think it's an interesting question, the way that the business activities exemption and the legitimate interest exemption can interact, along with the question of implied versus explicit consent. It's very difficult to answer this question in a few seconds. But broadly speaking, if we are to allow organizations to decide whether or not it's in their legitimate interest, then at a minimum, we need enhanced accountability and transparency measures. So it doesn't happen without the knowledge or consent of individuals, but there's a requirement for organizations to justify to the public why they believe this information is in their legitimate interest to collect and how they're protecting it.
Merci beaucoup.
Thank you.
Thank you very much. And now I'll give the floor to Mr. Lemire. Thank you very much, Mr. Chairman, and thank you to all of the witnesses. I'll begin with Mr. Bennett. In your submission of the 12th of February on C11, you made a distinction between interoperability and functionality. And I think it's interesting in the context that we're looking at here, they're working on here, because those two concepts can be confused within a single concept. So you illustrated the difference with an example that I'd like to refer to. The processes for looking at privacy protections should be interoperable between the federal government and the provinces. If there has an assessment being carried out under legislation, they need the assurance that that same assessment will be accepted in a different jurisdiction. However, that doesn't necessarily mean that there will be a harmonization or a convergence of those rules. So could you give us a definition of those two distinct concepts and tell us if the provisions of C27 would provide this interoperability between the two or a harmonization? And if so, which should we prefer?
Yes, thank you for that question. I was trying to draw in that statement a distinction between harmonization or convergence, which is a harmonization of text, ensuring that the text of the statutes essentially say the same thing, and interoperability, which I think means something subtly different, and means that if businesses have a requirement to do something in one province or one jurisdiction, right, such as a privacy impact assessment under Quebec's Law 25, that will in fact be accepted by a regulator elsewhere. And you can see that distinction in Canada between different provincial laws, which have worked out over time pragmatically, but it's also important to see it internationally through the GDPR. So that was the point that I was trying to make. And I think that I'm not an expert on Quebec law, but I was trying to point out certain areas in Quebec's law where I think businesses would be required to do more under that law than they would under the current text of C27. So then you have to ask the question, you know, what might be the economic impact of that across Canada if C27 is perceived to be, or the CPPA is perceived to be, lowering the standard within the Quebec Federation. So that's the point I was making, and I think the particular provision on international data flows is an interesting example, because in the CPPA at the moment, there's really nothing explicit for businesses on what to do when they are processing data offshore. And the vast majority of data protection laws that I know of, and this is also something that's of critical importance to the European Union when it comes to make a judgment about the adequacy, the continued adequacy of our laws in Canada. What happens when data on Europeans comes to Canada and then it is processed offshore elsewhere? Those are critical questions, and I think there'd be some concerns about that by our European friends when they come to make those judgments. I hope that answers your question.
Merci beaucoup.
Thank you very much. And talking about the insufficiency of Canadian law, you also in particular spoke in an article entitled "What Political Parties Know About You." You talked about components that would affect protection of personal data of Canadians that political parties might hold. So there are independent members, and in the context, C27 doesn't refer to that protection. The government should protect constituents' data, and they should have open transparency and governance. So do you think that Canada should follow Quebec's example and provide the same standards for federal political parties as in Quebec?
Well, thank you, and thank you for reading that work. I first wrote about this issue about 10 years ago when I issued a report to then Commissioner Stoddart on political parties and privacy. And it was obvious back then that there was a major gap in our law. Then Cambridge Analytica came along and the issue, hit the front pages, and there was a lot more attention to this. I'll say this. I mean, it's become increasingly indefensible and untenable for political parties to be exempted from or to say that they're exempted, to be clear, from provisions that businesses have to comply with. I don't think the issue is going to go away. Now, the question is, how that is done. And an easy thing to do would be to apply the CPPA to federal political parties. That wouldn't, and that wouldn't necessarily undermine what Quebec has done, although the Quebec law, in fact, is an amendment to your Elections Act, and it's by no means as far as I would want to go. In British Columbia, where the commissioner's office there has made a ruling that, in fact, that law does, in fact, apply to federal political parties as well as provincial political parties. That ruling is currently under judicial review, but you do have a real problem of his interoperability, to go back to your original question, meaning that it becomes absurd that provincial political parties should have to comply with a higher set of standards in BC and in Quebec than federal political parties federally. And I don't think that's in the interest of our political parties either. I mean, it needs to be fixed, and there needs to be, you know, there needs to be standards for federal political parties to comply with, you know, commonly accepted privacy standards of the kind that we are debating here with respect to businesses.
Merci beaucoup pour votre réponse.
Thank you very much for that answer.
Merci, Monsieur Lemire. Monsieur.
Thank you, Mr. Lemire. Mr. Massey.
Thank you, Mr. Chair, and I apologize to our guests for being a little bit late. Our Conservative colleagues were up to mischief in the House today, delaying things. I'm just kidding. Yes, we all were. At any rate, I'm just joking. So if I ask a couple of questions that are a little out of context, I apologize. I'd like to start with Mr. Geist here. And with the Privacy Commission, one of the things that's proposed to change is the creation of a tribunal. I'm just wondering if you have any thoughts about that. I have mixed emotions on it and thoughts subsequent to that. And I've also seen recently what the tribunal has done to the Competition Bureau. And I'm really worried that we could be in the same boat as that. I was told by administrative people from the department that that couldn't happen, but others are now telling me it can happen. So I'm in this little bit of a vacuum of space here and would like your opinion on that situation.
Sure. Thanks for the question. I did highlight it in the opening remarks, but happy to engage in. You're right. When we look at what we just saw most recently involving Roger Shaw, it's understandable why people, I think, would be understandably skeptical about the creation of a tribunal that provides that kind of oversight. That said, I think one of the things that we have seen over the years is that because of the way the federal court treats privacy commissioner decisions on a de novo basis, so if there are appeals, they go to the court, and the court then effectively starts from scratch. You're faced with a situation where it almost incentivizes challenging tough cases, and we've seen that, because you get another chance at it. You know, creating a tribunal, provided it is viewed from an administrative law perspective as an expert tribunal that's going to be granted some deference for the decision by follow-on courts, if it does go to courts, I think it has the potential, even in some ways, to strengthen sort of the outcomes of that process because there is some of that deference. But that requires ensuring that the tribunal is genuinely viewed as an expert tribunal and properly constituted. The initial version of this bill didn't go anywhere near there with just one privacy expert. We now have half. Finding ways to ensure that I think that public interest is well represented on the tribunal and ensuring that it's got genuine expertise, I think does at least open the door to the prospect that it might provide some advantages, though I recognize why some would say these are already lengthy processes. Let's just let the privacy commissioner handle it all.
So yes, let me just see if I got the summary of this right. So if we select and create a tribunal that's respected by the industry across the board, it might provide a better path to go forward versus, or if it's not, then it's going to lead for an opening to basically be an initial test drive to see whether we bring things to court. I'm sorry, I'm trying to figure this.
Sorry, let me just. It's not whether or not business respects the tribunal. I don't really care if business respects the tribunal. Okay, fair enough. That's why I'm asking. I mean, I think it should be properly constituted, that it should recognize that it's a credible, authoritative tribunal. But the question isn't whether or not business respects it, it's whether or not courts respect it. Okay. Because what we want is courts to say the decision that comes out of the tribunal is one that they are prima facie going to say that they're going to respect that decision. At the moment, when the commissioner issues a decision, the courts are going to start from scratch. They have the ability to start from the beginning, which is why we see, let's say in the case of Cambridge Analytica, it's already been referenced a couple of times today, we still have Cambridge Analytica before the Canadian courts, because we've had the commissioner, then we've had a first court decision, now we've got an appeal ongoing. These are long processes, and the courts play out potentially somewhat differently than the administrative side for privacy itself. So it's more about having the process of the privacy commissioner and the tribunal better respected by courts, especially given the kinds of penalties that we're envisioning, because I think we can well assume that if the penalties are significant, we're going to see the organizations facing those penalties going on and appealing those decisions through the courts.
Okay, so yeah, I've had a lot of confidence in the number of the last privacy commissioners we've had. But if the tribunal is going to be politically appointed, and if it's not respected by the courts, then okay, I see what you're saying, because their decision-making capability and evaluation is going to be based upon the confidence of the process the groups go through for the complaint?
Well, listen, I'm not an administrative law expert, but the way that administrative law works is in terms of the deference that the courts may give to tribunals, it is linked to the expertise of that tribunal. You see, let's say in the copyright context, and it doesn't mean that the decisions themselves are always followed, they're definitely not, but at least the starting point is that they recognize there has been expertise brought to bear. Whereas right now, even though I think we would all acknowledge the Privacy Commissioner has expertise, it's not viewed as that kind of independent tribunal, and thus the courts have taken the position that they have the ability to start looking at this case from the beginning.
Okay, that's very helpful. I know that we have some guests online. I don't want to shut them out. Is anybody on the guest? Please intervene. I know that there's several that we have here. Is anybody interested in commenting on the tribunal, the creation of the tribunal for the Privacy Commission? Okay. Yep. Please go ahead. Yeah.
Do you mean me?
Yes. Sorry, it's hard for us to see you. You raise your hand or just pipe in. It's all good. Thank you.
All right. Okay. Yeah. So I am less enamored with the proposed privacy tribunal for a number of reasons. And the first thing is that it's certainly true that the federal court under Section 14, in the Section 14 process in PIPEDA, specifically in the legislation holds hearing de novo. You can change that, right? You can keep the same framework, but you can require that it not be a proceeding de novo. So it is currently part of the legislation, but that part could be changed without creating a whole new data tribunal. Currently, the Privacy Commissioner doesn't make decisions and doesn't have order-making powers. The Commissioner makes findings. The process before the federal court is a process where either the Commissioner or the complainant seeks an order, or the complainant is seeking damages. It's not an appeal proceeding. The organization, for example, doesn't have a mechanism through that process to go to the court. So again, you could certainly tinker with that formula, but it isn't really an appeal. It's a hearing de novo on this issue of whether an order should issue. And with the Personal Information Protection Tribunal, the tribunal is actually going to now have the authority not only to review orders of the Privacy Commissioner, because the Commissioner will have new order-making powers, or to review recommendations for administrative monetary penalties, but can also hear appeals of any findings, because the Commissioner can still make findings. And findings aren't orders. They're not binding. They're the Commissioner expressing particular views about the law. And so those can also be appealed to the tribunal. And I think that requires another look in this context, because really what you're doing is you're taking an independent regulator and the approach and the interpretations that independent regulator brings to their decision-making role, and then you have an appointed tribunal that is going to review those decisions and those findings, those approaches, interpretations that are not binding, that are part of the Commissioner's approach to the law. One of the things that I've expressed concerns about is that the previous Commissioner and the current Commissioner have been working very collaboratively with the other provinces that have private sector data protection laws. So Alberta, BC, and Quebec, they have engaged in joint investigations. They have issued joint findings. They work in a way that is very collaborative to try and ensure some sort of consistency across the country with respect to interpretations of their laws, and to try and find cohesive shared interpretations of their laws. And we're going to move into a situation where the Commissioner has less latitude, because the Commissioner may agree with the other provincial commissioners who have order-making powers and are only subject to judicial review and not appeal before any kind of tribunal. The federal Commissioner will perhaps agree with them in joint findings, and then find those findings appealed to a tribunal that might rule otherwise, disrupting that collaboration between commissioners and disrupting that balance that might be found there. So I have quite a number of concerns about the tribunal structure and what implications it might have for how decisions are made about the interpretation and application of the legislation.
Great. Thank you very much. Thank you, Mr. Chair.
Merci beaucoup. Thank you. Mr. Viss, the floor is yours.
Thank you, Mr. Chair, and thank you to our witnesses here today. I'm somewhat concerned about this bad bill before us today. Bill C-11, the Government of Canada had an opportunity to enshrine a fundamental right to privacy in children, to define what a minor is, to define perhaps an age of consent, to do a whole bunch of stuff to ensure that children were protected. That bill died on the order paper. Then we had Bill C-27 when this Parliament opened up again, and the minister again had an opportunity to enshrine a fundamental right to children, to protect their privacy and some of the actions they may take online. Then the government had an opportunity to define what sensitive information is, likely in the context of a child. They had an opportunity to define what a socially beneficial purpose was in the context of a child. The minister came before us a few weeks ago, and he says, I have this bill, it's going to do so much work to protect children, but we have to amend it. Then we had to put a motion forward to get a copy of those amendments, and we're here today, and I am not going to relent on this until we have more clarification and I hear from as many witnesses as possible to ensure that children's rights are protected. So my question is open-ended. I guess I'll start with you, Mr. Geist. What clauses of the bill do you believe need to be amended to ensure that a child's fundamental right to privacy and their online actions are not used in a way that will compromise them as adults or at a future period of time in their life?
Well, I'll give you a brief answer, but Professor Krishnamurthy, who is one of the witnesses, has done studies and reports on this, and so he's probably best suited to answer some of those particular questions. But I will say two things in response to your opening. First, to reiterate, I think the general disappointment for many in terms of how the lack of prioritization of privacy over the last number of years. The bills, as you've mentioned, get introduced and then seem to languish. Glad that we're here now, but I'm inclined to agree with you that I think the best way to ensure that you get the best time out of witnesses and the best kind of study is to reflect on legislation as it's intended by the government. And so if we're left with this amalgam of the bill plus comments about where things are headed, I think that doesn't provide the best sort of study. Okay. In terms of minors specifically, I'll note one of the real concerns arises in terms of differing definitions of minors, province to province and the like. And so certainly one thing that we need to, I think, include within the legislation, I know other witnesses have highlighted it, is the need for some sort of consistent definition here so that we know there is that consistency of protection.
Thank you so much. And my colleagues tell me that I should be asking this question to Mr. Krishnamurthy. I apologize. I missed the opening statements. I was debating Bill C-34 in the House of Commons. Would you like to comment, sir?
Thank you very much. I agree with Professor Geist's initial responses. But let me just take a step back. So there are certainly specific clauses of the bill that could be amended to improve the protection of children and minors. However, we needed to consider the structure of the bill as a whole in protecting children and adults for that matter, right? So several of the witnesses, notably Professor Scassa and Professor Bennett, spoke about the interaction between the legitimate interests exception and the implied consent provisions of this bill, right? And when applied to minors, structurally speaking, right, those exceptions could be very problematic. So I think you need a structural approach to this, right? All of these pieces of this bill interact together, right? So what are the exceptions to consent? What are the situations in which someone collecting or using data has to go through a process to justify that? So a data protection impact assessment, right? What are the remedies? However, specifically, there are a few things that I would like to highlight, which I think are easy amendments, relatively speaking, right? So I think the first is the best interest of the child language, right? And that could be inserted into many.
Was that the language put forward by Mr., I believe, Terrien in the last meeting?
Correct.
The former privacy commissioner. Thank you.
Yes. So I think that is a very good First Amendment that could be made.
Why do you think we need that amendment specifically? Just elaborate on it, please. This is a really crucial point.
I think the amendment is important because it will influence the interpretation of all subsequent provisions of the bill. So, including in, a language that says that the best interests of the child need to be taken into consideration throughout the interpretation of the subsequent provisions means that if you're doing a legitimate interest analysis, right, that's going to be impacting that analysis by the company or other organization that's collecting and processing children's data. So that's a very good thing, and it's also in line with what's happening internationally, right? This is a provision that we see in the UK. It's in the California legislation. I expect to see this internationally in other jurisdictions as well. So
thank you so much, sir. We're going to work to ensure that the best interests of children are included in this legislation. Thank you.
Yes, thank you.
Thank you, Mr. Viss. I'll now turn the floor to Mr. Van Bynen.
Thank you, Mr. Chair. These discussions, previous meetings are very informative, and they've highlighted some key issues that we would like to take a close look at.
MP Van Bynen, I believe we have an issue with your audio. You're not on mute.
Better, Mr. Chair?
Is your boom properly placed?
I just replaced my boom. Is that better?
Yeah, that is much better.
Okay,
Thank you.
Sorry. So wouldn't be the first time we've needed to lower the boom in this environment. In any event, the information has been very informative, and I very much understand and appreciate the concern for consent and privacy. And some of the things that I've heard earlier also, though, is the risk of reticence. So if we become too strident in the way we manage data, are we going to be losing innovative opportunities? Are we going to be losing legitimate business opportunities? And how can that be structured so that we can balance the interests of both? And I'll start with Mr. Krishnamurthy.
Thank you very much for that question, the opportunity to address it. I don't think we should view this as a competition between innovation and privacy. The two can be harmonized. And the question is, how do we get responsible innovation that respects what is, I believe, a fundamental human right that all of us enjoy, to privacy? Now, I think it's very instructive to look at what's happened in the European Union since the enactment of the GDPR, which is that it has consent as one of 6 bases that an organization that collects and processes and uses personal data can use. Legitimate interest is a key part of the European data protection framework, and it is relied upon very extensively to provide all kinds of innovative services. In fact, in the European Union, as far as I know, and this is getting to ADA territory, it's the main way that training data for AI is acquired, right? But the European law, unlike what we're thinking of here, includes many more protections around the use of those exceptions to consent, right? So when we are relying on those exceptions in order to get innovative business activity or other forms of innovation, I think it's very important that there are, for example, and I've mentioned this before, data protection impact assessments that think very carefully and evaluate very carefully the interests of the data processor and what they're doing versus the interests of the people whose data is being processed. And, you know, when it comes especially to data that is sensitive, those protections are extremely strong in the European approach. And this goes to Professor Bennett's point that responds to another honorable member's question about interoperability versus harmonization, right? We can make our law interoperable with other laws, but maybe here's an area where a bit of harmonization with Europe would be good to protect the privacy rights of Canadians, but also to allow us to do business on a transatlantic basis, because we are going to have that strong level of protection that one of our leading trading partners has as well.
How would we strengthen the protection of international transfer of data?
I believe this is a question that may be best addressed to Professor Bennett, who has thought about this more than I have.
Professor Bennett.
Okay, thank you. Well, historically, there's two ways you can do this. You can do it the way that is included in PIPEDA, which is to put the onus on the organization to ensure that when data is transferred anywhere to a service provider, whether that's in Canada or elsewhere, the same legal protections apply. The problem with that approach is that it relies on contract or other business-to-business agreements, and the individual tends to be excluded from that arrangement. The other approach is to do what the Europeans have done over the years, which is a legal test, which is a jurisdiction-to-jurisdiction approach, which is to say these are the countries around the world to which personal data might be safely transferred. Now, the disadvantage with that is that it's a lengthy approach, it's highly legalistic, and at the end of the day, it doesn't do a lot to ensure that the data is actually protected on the ground. So the short answer to your question is it's complex. But as I said, I think that the approach which says that when a business is transferring data to a service provider, whether that's in Canada or offshore, it has to do an assessment. And not only assessment of what the company is doing, but also an assessment of the legal and the political environment. Because for economic reasons, our businesses transfer personal data on Canadians to countries around the world that do not have proper privacy protection, and in some cases have questionable human rights records. And I think Canadians would be pretty annoyed about that if they knew it was happening. So a business should have to assess that. And this is essentially what the Quebec law says. Do a privacy impact assessment and be actually broader than a privacy impact assessment and be ready to demonstrate their accountability for that data if and when a regulator comes calling. So that would be the compromise approach that I think I would suggest. But at the moment, there's, you look at this bill and you say, okay, a business looks at this bill and it says, well, what do I have to do? I want to transfer that data overseas. I want that data to be processed overseas. What do I have to do? It's not clear. There's nothing there. And most legislation, as I've said, has a section which is on international data transfers. And I think that would be something that I would strongly advise.
Great. With respect to the speed at which this is being addressed, I've often heard that perfection is the enemy of progress. And the reality is that the genie is out of the bottle with respect to data processing, with respect to internet, and the swift emergence of AI is a matter of concern. I've heard a lot of things of what are not right on this bill, but can you tell me 3 things in the bill that we need to absolutely safeguard to make sure that it's effective and it accomplishes the intent of protecting privacy of data? Go ahead, Mr. Bennett. Yeah, Mr. Bennett, go ahead.
Yeah, so yes, I think the powers of the commission. I'll just say that I'm not sure. There's several things in the bill about the new powers of the commissioners, the penalties, the sanctions, etc., which I think are an improvement and which advocates have been calling for a long time. The current situation under PIPEDA, where the Privacy Commissioner really just has recommendation powers, has been untenable. And many of us, Michael Geist testified back in the day, so did I, and we've been saying this for a very, very long time. So that is a clear improvement to give the Privacy Commissioner more teeth, more bite, not only in terms of fines and administrative penalties, but also some of the other things that he's able to do in the bill. So I just leave it at that, and perhaps my colleagues could also add.
I'm afraid we're out of time, Mr. Van Bynen, yes. So we'll have to stop there. Je passerai maintenant la parole à Monsieur Lemire.
Mr. Lemire, you have the floor. Thank you, Mr. Chairman. Mr. Geist, I'd like to discuss with you about the data collected by the government. So is there an example there of a component we should be concerned about? Do we consider that the public sector is just as subject to this as the private sector with C27? And can we ensure, or could we find that we're sufficiently protected by what the government's doing?
The conventional way to look at government-related collection of data is through the Privacy Act lens, which successive commissioners going back well before even the creation of PIPEDA have argued is insufficient and inadequate. And so government has consistently failed to hold itself to the same standard that it expects of the Privacy Commissioner. For whatever reason, Privacy Commissioners have we know the reason why privacy commissioners have regularly raised it, but it has rarely risen to the level of actual reform. In terms of the political parties, if the question is more around political parties and their potential application, because we've had several of the witnesses raising this. As I say, I think we can, if we're honest about it, it's pretty obvious why why they're not included. Because political parties have grown addicted to access to that data. They value that data. And quite frankly, they fear that if they had to actually get the same kind of level of consent that they are expecting businesses to obtain from users, they wouldn't get that consent. And so it would put that data at risk. This highlights, I think, for me, really two things. One, that I just think it's so obvious that if you claim that there's a fundamental right to privacy and we're going to elevate the expectations on businesses, please put up the mirror and have that same expectation for yourselves as political parties. It also highlights, I think, why there are real challenges with the law with respect to the private sector. Because just as political parties don't want to have any sort of limitations on the collection and use of the data outside of some bare bones sort of legislation, so too for lots of businesses who will also say, we're super innovative. We're acting in the public interest. Well, we've got a legitimate interest. We know all the kind of language that comes out of this. Fundamentally, they don't want to have to ask for an actual informed consent because they know they might not get it. And so we can see why you need to ensure in these rules that we hold those businesses to a higher standard, and I'd argue that we ought to be doing the same thing for political parties.
Merci beaucoup.
Thank you very much. Thank you, Mr. Massey.
Thank you, Mr. Chair. And yeah, no, that's a critical aspect because we didn't do that on the do not call. And I think that's a serious void that needs to be looked at. So I appreciate those words. If you were looking at this bill from our perspective in terms of if we're trying to make it work, and I know you have hesitations of kind of how we got here, what are the key components that you would suggest right now? And I know, sorry, I missed your opening elements, but maybe you can build on some of that, what we really need to the bare minimum get done.
Yeah. Well, I guess I would start part of the problem that I see, and I think it's been echoed by some of the other witnesses who may want to chime in, is that this omnibus approach that has combined both privacy and AI fundamentally, I think, really impairs the ability to have an effective review of the legislation as a whole. I mean, we are unsurprisingly having much of our discussion on the privacy side, which I understand that's where the committee was driving, at least initially. But the AI rules are critically important, as we've said, that we don't even have the full text associated with them, and the implications are enormous. And so, to me, the starting point fix for this committee is to say this is not working the way it needs to work for the committee to do its job effectively. We want to either shelve the AI portion altogether for the moment and either go back to the drawing board or say we're going to conduct two studies, or two committees are going to conduct studies, perhaps ETHI gets involved. There's got to be some sort of mechanism where both of these different pieces of legislation get the kind of attention that they deserve. In terms of the privacy side, very quickly on this bill, I would say, listen, I've highlighted the political party side. I guess I would again emphasize that, we will hear, and you do hear from many of your witnesses, we need to be innovative. We can't be out of step with these things. And I have to say, you need to recognize that this is to go back to the hearings back in the 90s. We saw the same kind of the sky is falling if you legislate in this way. You saw the same kind of comments being made in Europe when the GDPR was being developed. The reality is businesses will adapt, and they will adopt those rules and in many instances find competitive advantage for doing so. So I would urge you, as you go through the bill, you need to be looking for where can it be strengthened, where are there exceptions, and we've heard today many of the kinds of exceptions that are problematic, but most fundamentally recognize that the lens that needs to be brought here is not one of the scare tactics of you're going to harm innovation in this country. It's because that's just the basic playbook on privacy rules. It's rather how can we ensure that we've got the best possible law looking a decade or 2 decades ahead.
Just on a quick point, Mr. Chair, and that's why the NDP asked the Speaker for a ruling about this bill. and it's split in terms of votes in the House on two components, and then the A on the other one, is because they really were inappropriate. So we're going to study them together here, but the voting in the House of Commons will be separated from those two elements. Thank you, Mr. Chair.
Thank you, Mr. Perkins.
Thank you, Mr. Chair, and sorry I had an urgent call. I had to leave, so like MP Massey, I apologize if somebody covered this. My first questions will be to Dr. McPhail, and I want to start by saying we've had some interesting testimony already and some pulling teeth out of the minister to get the amendments that he said he would make and then refused to make and then made as drafts, which I think in some cases on privacy are wholly inadequate. But, you know, we had a Bill C-11 that the Liberal government brought in that was flawed, didn't listen to the Privacy Commission of the day, got responses afterwards when it was tabled that said it was a bad bill. You know, the 2021 election came along, so it died. The minister didn't bring in or listen to the testimony and brought in a flawed bill again and let it sit in the House for a year before we debated it, and then, you know, at the last minute decides after 4 years of battling back and forth that maybe fundamental, that individual privacy matters, and so we'll recognize a fundamental right. But here's my problem with where the government is. And I think Dr. McPhail and Dr. Skeza outlined some of the reasons why, and if you had watched my earlier questioning, because while they're going to the Liberals are going to put the fundamental right in the purpose section, the most important section, they also say the use of an organization to use that data is basically on parallel importance in the purpose of the bill. Then, as you've pointed out in Clause 12, there are issues in Clause 12 around consent and implied consent. And quite frankly, I thought implied consent was gone a long time ago in the 1990s, like reverse consent. And apparently implied consent still exists here that I can just say, no problem, Brad. I think you would have consented to this, so I'll use it anyway. And then in 15.5, as you pointed out, there's a huge problem because of the testimony we had earlier. And Clause 18, which I've talked a lot about, which basically says, no problem, big business can use your data no matter what the consent is if it's in their interest to use it. And it does say in that thing, even if it causes harm. So, and then there's Clause 35. And I brought Clause 35 up to the former Privacy Commissioner last time, which says that an organization, if it's using your data for research or statistics, can use it however they want, unidentified, directly. It doesn't say, like PEPIDA used to say, for scholarly work. Those words are no longer there. It says that an organization can use it, and an organization, and we know in this bill, is a business. And so my question is, there's a lot to fix in this bill to put the balance back to the individual. The Liberals have put the balance on big multinational data mining companies, Facebook, Google, and others, to have the rights to do whatever they want with an individual's data. So I'm wondering, is it simply removing Section 18, that the legitimate interest, that puts the balance, or do you have to make another statement of a higher level in the purpose, and do you have to get rid of Section 35 and replace it with what already exists in PEPIDA that's being removed here? So maybe I could ask Dr. McPhail and then Dr. Skeza to comment.
Thank you very much for that question. And the simple answer is it's not simply Section 18. There are a series of interlocking flaws with the bill. One of the other witnesses mentioned that you have to look at this bill in a totality. The clauses work together. So there are, as you have stated, many, many places where amendments could be used to strengthen the bill. Adding the fundamental right to privacy is an important one. I would reiterate my comment that it really needs to be embedded more substantively within the bill, precisely for the reason that you've identified, that one of the ostensible purposes of the bill is to balance an individual's now right to privacy with the business's interest in collecting and using information. To make sure we get that balance right, we need to make sure that the weighting of an individual's right is proportionate to the way that we're looking at the business interest. So adding that fundamental language is important. And there are a number of places, which I'd be happy to document in writing later, where I think that the bill could be improved by adding it.
Thank you, Dr. Skaza. I'm not sure if I'm...
It's Skaza. Thank you for the question. So one of the real challenges with this bill is that it's not just specific targeted amendments to the law that we had in place before, but it's a complete rewriting and reworking. And so many of these provisions have come over verbatim from PIPEDA. Some have come over verbatim, but related concepts have been changed or redefined. In some cases, there have been new provisions added and new language used. And as a result, there's a lot going on. And there are things that are, so there are the substantive concerns, and then there are the concerns about how the provisions interact with each other. There are concerns about whether there are legacy problems created because things have been carried over but not adapted to other concepts that have been introduced in the bill. And I think all of us that have been studying and looking at this bill have, we were asked to name the top 3 things. I think all of us, in coming up with lists of 15 or 20 or 25 things, have thought of those as short lists because there's a lot that you could comment on and address. And I think we've been trying to sort of, move up to the top things. I'm very concerned that we're going to find if this bill is passed over the course of the next few years, we're going to be finding, problems and issues in the bill relating to some of these other changes and language adjustments that we didn't address or didn't anticipate. And I think that this is a concern, particularly in light of Professor Geist's comments that, it takes an awful long time before there's room on the legislative agenda for further amendments. So I think this is one of the real fundamental challenges of this bill. And I am also sorry that this committee cannot fully devote its time to this and has to split the time between this and the AI and Data Act, which is very seriously problematic as well.
If I could quickly ask Mr. Geist about Dr. Skaza's comment about Section 51 and the ability to scrape data and use that publicly available information. I wonder if you would comment on that danger that this bill opens up.
Well, I think Professor Skaza is exactly right. I mean, anyone who's been paying any sort of attention over the last 5 to 10 years recognizes that what we once thought of, it's open and may be used. Oftentimes we're talking about data that didn't have the appropriate consent in the first place, and certainly not necessarily the consents for the kinds of reuse that you start to see online. So simply couching it as it's available so that you can use it without recognizing that many of those uses may be wholly different from what, even if there was consent obtained, and sometimes there may not have been, but even if there was consent, it may not be related to these new kinds of uses. So we've got to tread really carefully.
Thank you very much, and I'm afraid that's all the time we have, so we'll turn now to MP Lapointe for 5 minutes.
Thank you, Mr. Chair. My question is for Mr. Krishnamurthy. You wrote an article in May 2022 with a great title, I might add, that was called With Great Computing Power Comes Great Human Rights Responsibility, Cloud Computing and Human Rights. And in the article, you stated human rights impacts of cloud computing have not been studied to nearly the same extent as newer technologies that are powered by the cloud. So can you expand on this in relation to Bill C-27 recognizing privacy as a human right?
Thank you for that question and for also reading my scholarship, which I appreciate. Nice to see that it does get read. I'd actually like to address that question, if I can, in connection to the previous discussion around Section 51 of the legislation, right? Which is about how can data get reused, right? And there's so with publicly available information earlier in the statute with regard to use for statistical and other kinds of purposes, right? And I think this is a key point of interaction between the CPPA and ADA, or AIDA, if you want to be operatic about it. Which is that technology is changing very quickly, right? And we are seeing a proliferation of extremely powerful technologies, we'll call them AI, which have an interesting business model, right? And the business model is that smaller and smaller companies, those with less capacity than previously in terms of compliance and regulatory affairs and legal, are able to leverage extraordinarily powerful tools and do incredible things with our data. So in the article, I talk about a company that just takes pieces of Amazon's cloud offerings, right? A voice recognition system, a translation system, and a transcription system, data analysis, right? And creates automatic systems to monitor prisoner phone calls, right? So the uses to which personal data can be put once collected because of the AI environment that we live in, and the fact that these technologies are available with the swipe of a credit card to anyone, really changes what we're talking about when we're talking about privacy, right? So PIPEDA, when it was being enacted 25 years ago, we couldn't have foreseen this revolutionary change. And now we have this legislation and its two central components, and of course the procedural one with the parts that establish the tribunal. So given that changing landscape and given what we think is going to happen in the next 15, 20, 25 years with regard to technological advances that can more efficiently use our data and determine things about us that we didn't know, we need to be extremely thoughtful about both parts of the legislative package, right? So again, CPPA, I believe this is Dr. McPhail who mentioned it, right? This is the statute that governs the input of data into AI systems, right? For better or for worse. And the ADA will hopefully, with amendment, regulate the uses to which the systems can be put. So I think it's a critically important intersection that this committee needs to think about very carefully as technology becomes more powerful and accessible to more and more actors.
That's a really interesting position on that. And do you have real world examples that you can share with this committee to demonstrate the instances of human rights and privacy challenges?
Well, I think an excellent example that should be on this committee's mind and of all Canadians is Clearview AI, right? Which is a technology company based in the United States that takes publicly available information, right? Your photos on Facebook or on Tumblr or whatever else, and has developed a very powerful AI-based facial recognition system, right? Using publicly available information with no consent, right? For the collection or use of that. And of course, all the privacy commissioners who studied this came to the conclusion that this violates basically all existing Canadian privacy laws. And in this case, we have a company that's based in the US, so there's questions about how applicable law is. But I think it demonstrates several things, right? It demonstrates how some of these exceptions, right, are very susceptible to powerful forms of misuse. And then once you have ingested the data and you've trained your model, we also need the regulation of how it's used, right? So one could argue that there are some purposes where publicly accessible information can and should be collected and used, right? We could talk about that. However, the fact that it's not subject to any oversight, an impact assessment requirement, for example, is problematic when it comes to the CPPA part of the bill. And then we can talk separately about the many weaknesses of ADA.
And do you have any practical suggestions for this committee on how the legislation can address these human rights concerns?
So many of my colleagues who conceptualize privacy legislation think about its substantive provisions. You can do this, you can do that, but about privacy law as a process, right? So the idea is to get organizations that collect and use personal data to build governance around how they do so, but also accountability, right? So thinking very carefully about what are the uses and documenting that and having checks. So I think in my earlier comment, I talked about the overall framework of the legislation and the interacting components, right? And this is where I believe a stronger process orientation in both the CPPA, so that's the data protection impact assessment provision, which will interact subsequently with the enforcement provisions. And then when it comes to ADA, right, making clear, here are some uses that are beyond the pale that we're going to forbid, and then calibrating the legislation to the level of risk. So ADA right now really only governs systems that are high risk, and we don't know what those are, right? Because the criteria are not there. The European law, which I think is weak, could be improved, governs all AI systems presumptively. Even those that are low risk are subject to requirements that, you know, the people who are developing those systems have to actually show that the risk is low, right? I think that's a sort of key safeguard that if we're going to create legislation that is going to be durable for a long time, it needs to assess that entire risk environment, capture it in the legislative package.
Thank you very much. I'll now turn to Mr. Williams.
Thank you, Mr. Chair. Mr. Geist, tell me a little bit about the high impact systems using search and local media, comparing that to algorithms for search results. How does this bill address that, and what changes would you make?
Thanks for the question. Well, technically speaking, the bill doesn't address it because we have the bill. What we do also now have, as you know, is essentially a memo from the minister that highlights that they've begun to identify what they believe the high impact, or what they intend to include within the high impact systems. And as we just heard from Professor Krishnamurthy, the approach is to seek to regulate those and establish a number of kinds of regulatory frameworks around those provisions. Now, I think there is generally a consensus that it's appropriate to have rule sets around, and necessary to have rule sets around, particularly where there are concerns around bias coming out of AI systems. Think of the use of AI in labor markets for hiring. Think about it in the health sector. Think about it in the financial sector. Think about it with law enforcement. There's a lot of places where we can easily identify potential risks, potential harms, and the like. And so that's where much of the discussion has been. I think oddly, at least in terms of the list that has been provided, search engine algorithms, social media algorithms are included here as well. And while I think unquestionably we need algorithmic transparency with respect to these companies, and we need to identify ways to deal with the potential for harms that are coming out of this, let's say any competitive behavior in search results, it's clearly an issue that is raising some significant concerns. The notion that we would be treating that as a high impact system in the same way as we would law enforcement's use of this, or health, I mean, I just find very puzzling. I'm not aware of anyone else anywhere in the world that, as they work through some of these questions, has seen fit to do that.
Thank you. I'll cede the rest of my time, Mr. General, Mr. Chair.
Merci, merci, mon collègue. Merci, monsieur.
I thank my colleague, Mr. Geist. I thank the other witnesses as well. The way in the bill has been put forward, I know there have been changes that were asked for the former bill, C11, and the Prime Minister didn't really listen. The new version isn't much better. So now, after 18 months, we find ourselves with a bill where you have to come and testify here. And I'm asking the question because you referred to this earlier. We're going to have met about 100 witnesses during this process over a number of months. So how do you feel with the current process when we know that we haven't had access to the 8 amendments that were proposed by the minister? We had a few lines of it, but how do you feel about that? I would like you to tell us as a witness, not on behalf of others, but just so that people understand the process that we are involved in, actually, which I consider to not be successful. There are other witnesses that will be coming later trying to talk about a bill for which we don't have the amendments.
Sure. So thank you for that question. First, I'll say I think that there were improvements made from the prior bill to this bill. So, I mean, I think the government did listen, and some of the things that are in this bill are better than the one that was introduced in the first instance and really didn't go anywhere. But I will also say candidly, I must admit this is one of the hardest committee appearances that I've had in a very long time, in part because typically and I have appeared in omnibus legislation before, like, that we get, let's say, with the Budget Implementation Act, and when you're invited for a specific kind of provision, and we recognize how that works. In this instance, we've really got 2 distinct bills, perhaps more than 2, but 2 fundamentally on those 2 issues, plus, of course, the tribunal. You get 5 minutes. I recognize you don't get multiple appearances here, and you don't get multiple amount of time to deal with it. And so I do think, I look around even the witnesses, and people like Brenda McPhail and Professor Krishnamurthy and my colleague Teresa Scaza and Professor Bennett have enormous expertise across the board. I mean, because there is some correlation here. And so this just strikes me as not just an inefficient way of dealing with this, but I think, if I'm honest about it, I think an ineffective way. I'm trying to be effective with the responses that I'm giving. But there is obviously a limit from a time perspective. There's a limit in terms of what I could prioritize and the kinds of issues that I tried to highlight. And something's got to give, so to speak. At the end of the day, you can't talk about everything. And this would have been far better, I think, had we divided the two.
J'en profite pendant que le président ne regarde pas, là, mais
I'll take advantage of the chair not paying attention here, but I'm looking to you.
Le projet de loi essentiellement.
The bill, essentially, in fact, the provisions, you said it's always better for businesses than for individuals. So what do you mean exactly? And you talked about having a balance between the two. You're saying it's always better for businesses. So what do you mean exactly?
So, I mean, that was a reference to say that, I think, and we've heard it regularly, about a desire to strike a balance within these provisions. But let's recognize that once you get outside and start applying these rules, it's just not a balanced playing field, where many individual Canadians don't know their privacy rights, or if they do, the prospect of filing a complaint, of proceeding with it, of facing all the challenges that are inherent in this system, it's not, and this is true for more than just privacy, but it's certainly true with privacy, are enormous. And we've had a system that, for the last 2 decades, have left people really disappointed, because oftentimes they go through that process and are left with nothing other than a non-binding finding. I'm glad that this law seeks to remedy that. The enforcement side's important. But we need to realize that, especially as we bring in tougher penalties, which are one of the really good things that I think is in this legislation, it also means that those that are facing those potential for penalties are going to take a much more aggressive approach in terms of how they deal with these various complaints. It's not a level playing field, and so that means you need to embed within the legislation as much as you can to limit the ability for those businesses to take advantage of what is quite clearly a power imbalance between themselves and the individuals.
Merci beaucoup, Monsieur Turnbull.
Thank you very much. Mr. Turnbull, you have the floor.
Okay, thanks to all the witnesses. Sorry, I missed a portion of it. I was in the House speaking to another piece of legislation, but great to have you all here, and your expertise is greatly appreciated. Mr. Geist, you said just moments ago that improvements have been made. You've been somewhat critical today, I have to say. I wondered if I could ask you to just acknowledge some of the improvements that have been made and maybe speak and give a little bit more detail about those so we can acknowledge that as well.
Sure. Well, I want to speak specifically highlighting the importance that this legislation and give how important it is to include far improved enforcement measures. I think that the experience over the last couple of decades is that for many, if all you're left with are just non-binding findings, it is very tough to enforce, and it is, I think, tough for the commissioner to ensure that the companies themselves are compliant, because they will naturally engage in a bit of a risk analysis, at least under the current bill, and say, okay, well, what happens if I don't comply? Or what happens if I push the envelope a little bit? And the answer is, well, you might face an investigation if someone realizes and files a complaint. And at worst, at least initially, all you're going to get is a non-binding finding, and you need to try to do something. And we've even seen, I can recall an instance, I believe it was with Bell, that rejected some of the initial findings of the commissioner until there was some pressure and they came back. So we've seen the companies take a pretty aggressive approach. I'm glad the government has seen fit to really improve on the enforcement side, both in terms of the powers the commissioner has, as well as in terms of the penalties that are associated with the legislation. I'm glad it's seen fit to begin to adopt some of the kinds of provisions that we've seen in Europe. It's long overdue. They're not quite the same, or at least identical, but nevertheless, it moves us in a direction. So absolutely. Listen, I think that there are things that improve on our existing legislation. That legislation is more than 20 years old. We need to fix the legislation, but as I say, the point of emphasis for myself, and we've heard it from others as well, is that if you're in all likelihood only fixing this bill or this legislation every 10 or 20 years, you can't rest on your laurels to say, here, we got a bunch of things right, when there are all sorts of other things that need fixing.
Do you agree then that it's really important to see this bill through, given the fact that our legislation is 20 years old, recognizing for sure that we've got to have a critical lens as we debate this bill and certainly work towards strengthening it? I know you've outlined multiple ways, but what are the repercussions if this bill fails, which it has once before? So, I mean, I think we need to really push forward. So could you speak to that? How are Canadians going to be impacted if we don't have updated legislation?
Well, yeah. I'll speak candidly in telling you that with the first bill, with all due respect, the government did not move forward with it in any meaningful way at all. So, I mean, that's just the reality under Minister Baines. Under this bill, I feel, and I can't speak for other people coming out of the privacy community, but it is a source of significant frustration that we get a bill that barely makes it through anything. This one also took a year from introduction until we're finally before committee. We've got 2 bills embedded or 3 bills embedded within the same legislation, and then the question is posed: well, it might not be ideal, but isn't it better to isn't something better than nothing? Yeah, something is better than nothing, but if we are truly going to try to prioritize privacy as such a critical component, I believe that Canadians expect better than a bill that doesn't really meet the kind of expectations that have been regularly identified before you.
Okay, maybe I can ask Mr. Krishnamurthy whether you feel the same way, or whether you can recognize that there's some significant improvements in this bill, and what would be the repercussions if we don't move forward with updated legislation.
Yes, thank you for the question. So undoubtedly, the C-27 package of amendments is an improvement over the status quo. I think all of us would acknowledge that. However, I'm not sure we should settle for a C+ bill. I think Canadians deserve A+ privacy protection myself, and amendments to this bill can get us there, right? And I think that is the spirit in which all of us who are scholars and activists who think about privacy and take a big picture approach to this and understand that private information does need to be collected and used, processed, but it needs to be done so in a way that respects what is a very fundamental human right, one that is becoming more important in our digital age over time as technology becomes more invasive, that it is important to get that right because political oxygen is scarce. We will not be, again, you have many priorities, many things to legislate. So if this is our shot, we have to do our very best. And I think everyone here today has provided lots of really good ideas that if this committee would embrace and enact some amendments, this could be a much better bill.
Yeah, I mean, you're speaking to the importance of this process, which I think we're all very committed to. And I was just trying to get a sense that if this bill stalls for any longer, what the repercussions were going to be. But I think you've answered that well enough. Maybe I'd just say quickly a couple of things based on some testimony that we've heard. The ADA portion of this bill went through over 300 consultations. So I think there's been a lot of consultation that's happened. I'll just put that out there. And in relation to some of the comments made about political parties, the government has been carefully studying the Chief Electoral Officer's recommendation on strengthening privacy measures. And we will be having more to say about that in due course. So just to let you know, just for information purposes, I think that's helpful to reassure folks. And maybe I'll leave it there.
Thank you, MP Turnbull. Monsieur Lemire.
Mr. Lemire. Thank you, Mr. Chairman. It was interesting, the discussions that we've had, but at the same time, I'm wondering about the will that we have or the ability we have as a committee to really move forward quickly and to help this bill get passed, or even if at this stage, honestly, how am I going to do this if the government really does want it to be passed or not in the context of the current legislation before us? Having said that, I would like to ask Dr. McPhail, in your publications, you put a great deal of emphasis on the development of responsible artificial intelligence and as well as a transparent governance of AI. Because this development of this new technology represents significant challenges. So what do you think about a technological sandbox that would allow us to develop these technologies in such a way that it respects privacy before being put at the disposal of the public?
Thank you very much for that question. There are a range of ways in which the ADA could be improved to facilitate truly responsible AI governance. The idea of a sandbox is an interesting model. Some of the big problems with the ways that artificial intelligence tools are currently developed is that they are created and they are tossed out into the wild, and then we see what happens. A sandbox, to the extent that it would be able to mitigate the risk, that kind of risk, is a really interesting concept. I would note that there's absolutely nothing in the current bill that actually fosters the creation of such a sandbox at this time. Of course, that's only one of the many gaping holes in the truly skeletal structure of ADA that even with some of the potential amendments that have now been floated, still has a long way to go in order to be this effective bill that people across Canada deserve, which is why many of us have actually called for a reset of that bill rather than a revision. It is so fundamentally flawed that it's hard to imagine how you're going to make it something that truly respects Canadians' rights, that truly reassures Canadians that artificial intelligence is a tool that can be used across all sectors of our economy as it is envisioned to be used safely and with respect for their privacy rights. We've heard a little bit about reticence risks. I would counter reticence risk, which is a business concept, with social license. Members of the public are deeply concerned that their information is being collected and used in ways that they don't understand, often without their consent, something the CPPA would facilitate, and for purposes that they disagree with fundamentally. If we allow our AI Act to take that data collected in that way and leverage it in tools that, again, members of the public find it difficult to trust, we are not fostering a vibrant innovation economy in Canada. We are fostering a distrustful society that will not believe their government has their back and will be genuinely reticent as citizens to use these technologies in a way that we would like them to if we take seriously the idea that this technology has immense potential to improve our world used responsibly.
Merci beaucoup. Mon temps est dépassé.
Merci.
Thank you. Thank you, Mr. Lemire.
So I'll again yield the floor to me, and I have. Thank you. I have my first question is regarding Section 35, which MP Perkins has brought up, and I'll ask it to Professor Geist. But if anyone wants to volunteer comments, Section 35 provides that an organization may disclose an individual's personal information without their knowledge or consent. Subsection C is, to me, the oversight of that disposition, which requires the commissioner, the organization, to inform the commissioner of the disclosure before it is disclosed. So, is this a sufficient form of oversight for that sort of transmission of personal information?
I think we could, I think there's reason for concern based on just the load that the commissioner is facing. Let's realistically. We've had a situation for the last number of years with Privacy Commissioner where findings sometimes run between 12 and 18 months because there just simply hasn't been the resources to deal with issues. If this gets interpreted aggressively by organizations to say, well, it's impracticable to obtain consent, so let's just run off and ask the commissioner, I think there's a concern that there's delays, which businesses aren't going to be happy with, but is this going to get the sort of study that's necessary? But I'd be curious to hear what some of my colleagues on the panel think.
Yes, Professor Krishnamurthy.
I think it's positive that the disclosure does need to be made to the commissioner when this happens. However, I think we need to question how much the oversight the commissioner can exercise. And again, this is a point of interaction between the CPPA and ADA, right? What kinds of research for our statistical purposes might organizations make? It might well be to train AI models. And we now know from research that when data is used to train an AI, AI systems can retain that data. It's called imprinting, I believe, is the technical thing. And if you use ChatGPT and you use it hard, you can probably get an AI system to spit that data back, right? And that's a big problem. right? So the mere disclosure to the commissioner that this is happening without some kind of analysis of what are the risks, right? And this is why I keep coming back to this data protection impact assessment point. It's so important that that weighing occurs, right? What are the relevant risks? You know, we want to incentivize research, of course, but let's remember, Cambridge Analytica was a research organization, right? It was a research disclosure of data that was the beginning of that terrible privacy scandal, right? So that safeguard alone is not enough, right? I think we need more. And I'm very interested in research. I'm an academic institution. I want to promote that. It's a very pro-social thing. And there is a real anti-commons problem with trying to get individual consent every time. But the safeguards need to be stronger.
Okay, the second question is regarding section 39 for so socially beneficial purposes. So my understanding is so the information needs to be de-identified, and it can be shared to the government or government institutions, the healthcare institution, post-secondary educational institutions. So I gather it would be, for instance, at the request of a government department or organization that the information which is de-identified, that's for sure, is shared. But then I'm just wondering, should there be then here as well the same kind of oversight that we're seeing in Section 35, that at least an organization that is transmitting this information to the government be required to disclose it, because otherwise we can envision ways in which that would happen where the public wouldn't even be aware that this information. And I get that it's for socially beneficial purposes, but that can be interpreted quite broadly. Professor Geist.
Yeah, no, I think that's right. I was going to say Professor Skaza's done. I know a lot of study on that. She's probably ideally suited to comment, but I think you answered your question yourself. It does indeed open the door to a very broad interpretation, which I think is the source of concern.
Professor Skaza?
Yeah, and so I don't know what just happened to my camera, but anyway, I completely agree that there are problems with this provision. The one that I flagged in my opening comments is it refers to de-identified information. This was taken verbatim from C11 and put into C27. But in C11, de-identified was given the definition that is commonly given to anonymized information, right? Under C27, we have two different categories, de-identified and anonymized. And anonymized is the more protected. So now you have a provision that allows de-identified information, which is the less, it's not anonymized, it's just de-identified, to be shared. And so there's actually been a weakening of Section 39 in C27 from C11, which shouldn't be the case. And in addition to that, there are no guardrails, as you mentioned, for transparency or for other protections where information is shared for socially beneficial purposes. And we, the Ethics Committee held hearings about the mobility, the PHAC use of mobility data, which is an example of this kind of sharing for socially beneficial purposes. The purposes may be socially beneficial. They may be justifiable. It may be something that we want to do. But unless there's a level of transparency and the potential for some oversight, then there isn't going to be trust. And I think we risk recreating the same sort of situation where people suddenly discover that their information has been shared with a public sector organization for particular purposes which have been deemed by somebody to be socially beneficial, and they don't know, those people don't know, they haven't been given an option to learn more about it, they haven't been able to opt out, and the Privacy Commissioner hasn't been notified or given any opportunity to review. So I think we have to be really careful with Section 39, partly because I think it's been transplanted without appropriate changes, and partly because it doesn't have the guardrails that are required for that provision.
Yeah. Again, feel free to send any suggestions on how we could strengthen Section 39. You've mentioned some already with regards to anonymized instead of de-identified, but also if at least the organization needs to inform the commissioner. So if you have any specific wording and that goes for all witnesses, you can send through the clerk potential amendments that you deem worthwhile. One last question. Are there jurisdictions where a constellation of publicly available data on an individual becomes sensitive information or like personal information that ought to be protected? Because with the systems that are capable of gathering publicly available information, when you gather enough data points on an individual, it can become sensitive. Are there jurisdictions that do that, and are there examples you can point to?
If I can jump in, I mean, one example would be, Clearview AI scraping publicly available information. They scraped photographs of individuals from publicly accessible websites. And then what they did was they created biometric face prints of those individuals in order to create their facial recognition database. And we all accept, I mean, it's broadly understood in the privacy community that biometric data is sensitive information. And so, a picture of you receiving an award at a public event or giving a speech, for example, as a member of parliament, is turned into biometric data that populates a facial recognition database. And so I think it goes from being an innocent photograph to sensitive biometric data very quickly. And that's just one example.
Okay, Professor Krishnamurthy.
Yes, Mr. Chair, directly responding to your question, Article 9 of the European Union's GDPR is very instructive in this regard, because it says that the processing of personal data that reveals sensitive characteristics, right, is subject to the heightened protections for sensitive data. So the data may be anodyne at the beginning, right? But as I tell my privacy law students, right, what I buy at Loblaws can be very revealing of my health if I'm buying a lot of potato chips and not a lot of fresh fruit. And that can become health information, right, through processing and through the correlation of my data on my shopping habits with large-scale statistical studies. So I think that's a very important point that you've raised. About protecting what the processing reveals.
Thank you very much. And I know, Mr. Perkins, you wanted to ask one last quick question very shortly.
If I could, of Dr. McPhail, in your opening testimony, you mentioned that we need to dig deeper in ADA than high-impact systems, which the minister has now defined and then redefined. But so... at what level down? Could you expand on that a little more beyond high impact? Well, I guess one, is high impact now properly defined? And two, what other level or examples of things that you think need to be incorporated or captured by the ADA portion of this bill?
Thank you for that question. I think it's been mentioned already today, but I will repeat it. Merely looking at high impact systems, however they're just defined, and right now that's unclear in the current amendments, is not enough to fully mitigate the risks of AI, particularly the collective risks to communities and groups, and that kind of risk, furthermore, is not covered under the current definition of harm in the bill, which is focused strictly on individuals and quantitative forms of harm. So in looking at how we could restructure that better, I would refer you to something like, we could look at the European Act, but something closer to home. The Toronto Police Service recently did an extensive public consultation and developed rules on artificial intelligence for use by their service, and adopted a tiered approach, where there are some systems that are deemed low risk, but require an assessment in order to determine that they are so. There are some systems that are deemed medium risk, and there are a different set of precautions and safeguards in order to ensure that those risks are appropriately analyzed and mitigated prior to technology being used. There are systems that are considered high risk, which have the highest level of protections and safeguards. And then there are systems that are considered beyond the pale. There are systems which are considered so risky that it is not appropriate to use them in a country governed by the Charter of Rights and Freedoms, where democratic freedoms are valued. So that's much more tiered and nuanced approach, requiring assessments at different stages, but then proportionate safeguards and restrictions depending on the level of risk, can be much more finely tuned and can be much more responsive to the genuine concerns that members of the public have about ways AI systems can be used for them or in violation of their beliefs and values and against them.
Could we get the analyst to provide us, or the library to provide us with a little outline of the Toronto Police Service policy that was just referred to?
I'm sure it can be sought for and found. It's available online, yeah.
Thank you.
Thank you very much. This concludes our meeting. Thanks to all our witnesses. It's been a very informative discussion. And thanks in particular, Professor Bennett. We've seen the day rise in Australia through the blinds behind you. So thanks for waking up so early to meet with us. Much appreciated. Merci aux analystes, aux interprètes, aux greffiers.
Thank you to the analysts, the interpreters, and the support staff. The meeting is adjourned.
Australia.